evening. Welcome, everyone. I'm Ms. Taylor from the Brussels Privacy Hub and Trilateral Research. And on behalf of the Brussels Privacy Hub, and particularly its co-directors, Professors Paul de Hurt and Christopher Kuhner, I'd like to welcome you here today to tonight's event on state surveillance. The opening screen has gone. On state surveillance through the lens of the ePrivacy reform, or rather I should actually foreground that it's about the ePrivacy reform. And it's as something under discussed, we thought we could have an event about it to kick off CPDP. And tonight's panelists are Estelle Massé, who will be chairing the event from Access Now, Frederik Zuiderveen Borgesius from Radboud University Nijmegen, Cornelia Kutterer from Microsoft, Joris van Hoboken from the Vrije Universiteit Brussels and from the University of Amsterdam, and Peter Eberl from the European Commission DG Connect. So without further ado, I'm going to hand over to Estelle, and I hope you enjoy the event. Thank you.
Thank you, and thank you everyone for being here. Good evening. My name is Estelle Massé. I'm a senior policy analyst at the international NGO Access Now. And as it was mentioned, I have the pleasure tonight to be the chair and moderator of this session, which means that I get to do a short introduction of the topic, and then we'll move on to our expert panelists who are here with us tonight. As it was mentioned, we chose to discuss state surveillance through the lens of ePrivacy, but really the focus of tonight is, of course, the ePrivacy reform and some of the many issues surrounding the fact that we're still here 3 years later. And yes, 3 years after the proposal was launched by the European Commission in January 2017, here we are again, meeting, discussing what are the issues in the ePrivacy reform. Since the proposal was first launched, the European Parliament has adopted its position in winter of 2017, and we continue to wait for the member states in Council to reach the same level of agreement. The latest news from the member states came today through a presentation of the new Croatian presidency in the Libe committee. The presidency indicated that they will be presenting a new text on the ePrivacy reform in February, but they gave very little information of what would be in this new text. So I guess we'll still have to see, but it means that despite the many ups and downs, the several confusing announcements, many calls for repeal the reform, we're still here and the reform is still ongoing. So why is it taking so much time? What are the deadlocks? Well, first we should acknowledge the massive amount of lobbying for and against this reform. We've seen calls for the EU ePrivacy Directive or EU reform to not happen, for the law to be repealed, for the EU to take its time to do this reform because of the ongoing enforcement procedure on GDPR, et cetera, et cetera. The level of lobbying that we are experiencing on this legislation is quite unique, and it's reaching a level or even surpassing a level of lobbying experience during the General Data Protection Regulation, which at that point were unprecedented. This means that negotiations are particularly tense. And if you add to that it's also a quite complex file. It's not necessarily complex in its objective, which is quite clear. It's a user's right protecting framework to protect the right of privacy, to protect confidentiality of communication. But throughout the reform and within the text, it has gathered a lot of other interest. For instance, member states see in the ePrivacy as a law that could potentially impede in some of their national legislation that put forward some surveillance measures and in particular mass data retention measures. For those who've perhaps not been following the debate so actively, maybe this the connection between the two is not really clear. So that's what we want to do tonight and focus on tonight is to analyze to which extent the privacy reform is linked or not to state surveillance. And I will try to provide some basic context and explanation through the lens of the recent opinion of the Advocate General of the European Court of Justice, who just last week, on January 15, presented its opinion in 4 new cases related to data retention on laws in the UK, in Belgium, and in France. And those laws were analyzed in relation to the EU Charter, of course, EU law, but more specifically to the current ePrivacy Directive. The ePrivacy Directive, as well as the current, many versions of the current proposed regulation, include an article that provide for some limitations that allow member states to put forward laws that would not have to completely follow the requirement of the ePrivacy Directive, including via data retention law. For a lot of actors, including civil society, this clear limitation framework means that then the measures put forward by the state are still linked to EU law, because through the limitation comes the fact that the law applies. Member states, however, understand that since most of the time they're doing those laws for national security purposes, it's fully outside the scope of EU law, and therefore we cannot make the directive applicable. And why is this relevant? It's because when EU law applies, when a national law falls in the scope of EU law, it means that the Charter of Fundamental Rights applies, and it means that the rights to privacy, data protection, and all others encompassed on the Charter must apply, which then allows the court to trigger some criteria and put forward some safeguards that the state have to follow, even though it might be a national law. The Court of Justice of the European Union has already provided in details how data retention measures should be applied in relationship to the ePrivacy Directive in its ruling on Digital Rights Ireland, TILI 2, and Ministerio Fiscal. So we already have 3 rulings in those cases. And in each 3 rulings, the Court has been clear that state cannot mandate communications operator to provide for mass indiscriminate retention of data. And the court has then also established some criteria on how public authorities can access the retained data. But following those decisions, many of us thought that there would be some clarity on what can and cannot happen on data retention in the European Union, in particular on the scope and the mass and indiscriminate scope. However, what we have seen is that it has created more debate through the states on how to continue having mass data retention, and this became a central component of the current ePrivacy reform. Indeed, through the reform, we've seen some proposal coming out of Council trying to clarify, but really it does not apply to national security, so any laws that we do for that purpose, the ePrivacy should not apply, et cetera, et cetera. And here, perhaps the new opinions that was just released by the Advocate General Campos Sanchez, if they're confirmed by the court, could help move along this discussion. The opinions show that no matter the purpose for which states mandate telecom operators to do data retention, they still fall under EU law, they still fall under the ePrivacy, and this is why the jurisprudence and EU law needs to be respected. And here is why also the Advocate General, even starts to draw some potential indication of it's not just the ePrivacy, it's other EU instruments. So these laws needs to respect EU law. The Advocate General explains that the ePrivacy Directive applies to any obligation you put on telecoms operator. So if a state comes and tells the telecoms operator, you have to keep the data, even if it's for national security purposes, it falls under the scope of ePrivacy because the state is not doing this activity on its own. It needs the telecom operators to do that. So that's the first reason why the Advocate General is saying, yes, even though your law is a national security purpose, it's still under EU law, you have to respect the Charter. And the second interesting point that the Advocate General is saying is that another reason why these laws are still applying even in the context of national security, it's because if you look at the architecture of the ePrivacy, and this is the nice caveat, and of the General Data Protection Regulation, this law includes article on limitation to the application of these laws. But clearly, if the state did not want those laws to apply to national security, then they wouldn't need to create article, which is the Article 15 of the current ePrivacy Directive, 11 of the proposal, and 23 of the GDPR. You would not need to have article on limitation on how national law applies, apply GDPR or ePrivacy rules in the context of national security, if you would assume that it would never apply. It's a quite secular argument, but the Advocate General said that those articles means that the application, without it, the application of EU law would be superfluous, so the fact that they exist means that EU law applies. So no matter what political solution member states are trying to find in the current ePrivacy reform, the court is trying to confirm, and the Advocate General is trying to get the court to confirm that mass data retention is not possible in the EU, and you will have to find another solution because this cannot be authorized. And what it's more, it should not be authorized through a legislation such as the ePrivacy, the ePrivacy regulation, because in here, this is not the Advocate General speaking, this is me again. The ePrivacy regulation objective is to protect privacy. You cannot turn it into a surveillance framework or a law enforcement framework. So hopefully with more clarity from the court, we can help, there can be hopes that it helps Council move forward on that particular element, and we can get to discuss the core of the reform, which is the right to privacy and confidentiality of communication. It's been 3 years now, and it's really high time to bring the privacy reform to its final stage. It's a much needed instrument for many other reasons that are unfortunately not discussed because of the many surveillance components around it. So I mentioned data retention, but our panelists will probably mention other issues that came up through the 3 years of reform that we have seen. But this has impeded having actual discussion on interference of content and the rule around that. But without the ePrivacy reform, there is no fight against disinformation because this is a law that can help better protect people against privacy invasive tracking and targeting. There is no addressing the ad tech business model without having the reform of the ePrivacy, and even with this reform, we might need further action from the EU. There is no protection of confidentiality of communication elsewhere in the EU instrument, except within the ePrivacy, so we need this law to continue being there. And there is no immediate opportunity for the EU to put forward rules on privacy by design and by default that could help industries such as the IoT sector to bring trust in their area without the ePrivacy reform, which has a concrete proposal on it. But of course, despite all of this interest, the story of the ePrivacy is not written yet. And tonight's discussion is trying to wrap up the 3 years of reform, the deadlocks that are still facing ahead, and how we can avoid turning the ePrivacy into that state surveillance framework, which is not intended to be and which is not the spirit of the law and would be in contradiction of what the court has been saying for many, many years. To not enter into too much more detail for now, I'll kick the discussion with our panelists. Our first speaker tonight will be Frederik Borgesius, who will walk us through a history of privacy and confidentiality of communication. Thank you.
And I'd like to use some slides, so I'm waving to the thing. Yes, so I'm going to zoom out a bit and remind us a bit of the history of surveillance of communications in Europe and legal reactions. So this gentleman is Louis XI, and before him there were some different commercial companies delivering post in regions of Europe. He was the first who thought there is profit in delivering the mail, and who realized if you deliver the mail, you can read all the letters of your citizens, and that is practical. So he did that. And this is his colleague, Louis XIV. He continued to make money on delivering the post, and he read people's letters on industrial scale. His office that opened letters was called Le Cabinet Noir, but it happened all over Europe, in the Netherlands, in Austria. They had a system where they got letters that were put in the mail. They got them at 7 in the morning, steamed open the stamp. How do you call it? A zegel. Steamed open the seal, copied it, closed it, put the seal on it again so that people sending it and receiving it didn't notice, and a letter was on its way again within 3 hours. So on an industrial scale, people's communications were being read in Europe. And then we got the French Revolution, and that led to the Déclaration des droits de l'homme et du citoyen, with early versions of many human rights. People didn't talk about the right to privacy back then yet, but there was a right to freedom of expression in this declaration. And in the draft versions, there was also a right to secrecy of the letters. But that was like a paragraph 2 of the right to freedom of expression. The idea was that if you want to publish a book somewhere that's important for your freedom of expression, you should also feel free to send that book to your publisher without being afraid that the king opens it and reads it and intercepts it, etc. In the end, they didn't even include secrecy of the letters in the Déclaration because it was for them so obvious that freedom of expression also protects your letters that they didn't even put it in. Now I'm fast forwarding a couple of centuries. After the Second World War, from a legal perspective, the right to privacy started to flourish. At least in legal text. So for instance, in the Universal Declaration of Human Rights of the UN, it says that we should not be subjected to arbitrary interference with our privacy, family, home, and correspondence. So there's secrecy of the letters. Similar in the European Convention on Human Rights, it says that all of us have the right to respect for our private and family life, our home, and our correspondence, again. Later on, the Court of Human Rights says correspondence also means phone calls and emails, etc. In the European Union, we now have our own human rights text, and here the right to privacy is literally copied from the European Convention on Human Rights, but here the phrase is more technology neutral. Each of us has the right to respect for our communications. So, a long history of communication surveillance in Europe, and a shorter, but still somewhat long now, 2 centuries tradition of a human right to secrecy of communications. So why are these texts protecting the confidentiality of our communications? We can summarize the reasons in 3 categories. First, of course, privacy. If somebody reads your emails or checks out your metadata, that infringes with your privacy. As the French lawmakers said around after the French Revolution, it protects also our freedom of expression because for instance, if you're planning a demonstration, you want to be able to call your friends and to email your friends, etc., without too much of a chilling effect. And a bit more legal technical, it also protects the trust in our communication channels, because if you think that all your letters are being read all the time, or if you think that our cell phone companies analyze our metadata all the time and so, you may feel uneasy even using those communication channels. And so, but these were still, we were talking at the human rights level. Now I'm going to move to ePrivacy rules. One of the big success stories in the European Union is that the European Union cut up the state monopolies on telecom. So therefore we call cheaply now, etc. But the human right to confidentiality of communications protected people against the state and was not written to protect people in what lawyers call horizontal relations against companies. So what did the EU do? They cut up the state monopolies, but then the vertical human right to communication confidentiality didn't offer enough protection anymore. So they wrote the first ePrivacy Directive in 1997. And the core of that directive was a right to secrecy of communications or confidentiality of communications in horizontal relationships, so protecting us against, back then, phone companies, nowadays cell phone companies, etc. By the way, this ePrivacy directive took 7 years of negotiations, while the Data Protection Directive only took 5, so I hope we're quicker now. But this suggests that ePrivacy from the start has been more controversial or more victim of lobbying and difficult discussions than data protection rules. So, to summarize, now we're still working with the ePrivacy Directive rules of 2009. The proposal from 2017 has been, let's say it in an optimist version, has been delayed. But the idea was, at least in the version of the European Parliament from October 2017, the idea was that the proposal should have ensured that our electronic communications shall remain confidential in the history of or in the tradition of the human rights declarations from 2 centuries ago. So that's the bigger picture, the history of what we are discussing now. Thank you very much.
Thank you. Before we move to Cornelia Kutterer to give us the perspective of Microsoft on the ongoing reform and the topic we're discussing tonight, I also just want to let you all know that after the speakers do their introductory remark, we'll try to invite you also to come to the discussion because, as it's been said, it's been a topic widely discussed not just in Brussels, and we want to make sure that you can also contribute with question and see how we can all find a way forward in the reform. Cornelia, thank you.
Thanks. Thank you very much. And for a certain reason, I think a discussion I had a couple of months ago with Paul de Heer led to conversation today, and I want to, as a preemption, say that I'm speaking more freely and on behalf of my own, which helps to have an open discussion. We just discussed when we engaged for the first time on this proposal, and I think the first discussion I had was not 3 years ago when the Commission adopted the proposal, but 4 years ago when Jan-Philipp Albrecht had the first this public hearing in the European Parliament a year ahead of the adoption of the proposal. You could see that this has been of a high interest even before the legislative proposal started. And I think you were there, by the way, too. So, and at the time, I was saying what I'm saying now again, which is when we think about adapting the ePrivacy Directive into the new world, we shouldn't start from a scope that relates to a market regulatory scheme, which is the Electronic Communication Code. The Electronic Communication Code, for the better or worse, has included OTTs into its scope in order for the telecom regulators to have a mechanism to protect consumers in that space, but also have a market surveillance instrument by, for example, being able to request information from the companies that fall into scope. That's one thing. And again, you can agree or not agree whether this had made actually sense to include OTTs into this scope. But when you're looking at the protection of a fundamental right, you shouldn't start from a market regulatory instrument. You should actually start from what it means communication today. How do we actually communicate? And we shouldn't be constrained by the fact that in a market regulatory instrument, you have certain services that fall in scope and certain services that do fall out of scope. That's the first thing I would say. The second thing that I say is then you have to think about the history that Frederik has just described eloquently and really well researched. This was largely an instrument to protect against the state. the relation between someone who provides a specific service, where in the relation someone who carries a message has very different entities. So we have not looked at what the services are actually doing. I go back to my first point. I today can communicate super well with Google Docs, share document. I communicate the whole time with you. Google Docs or Word document or any other text that you store in the cloud and you can share is actually not covered by the electronic communication code, but you very well can actually communicate with these type of instruments. From a fundamental rights perspective, there's a gap in what you're actually protecting nowadays. So this is sort of where do we start when we want to go somewhere. That has 4 years ago, I've already said that. Again, we have, when we look at transmission, we had a really interesting discussions with the Commission. Where does transmission end? So the old version of the ePrivacy Directive was saying when it is received by the user. And of course, at the old days in technology, that was when I took the phone or hung up the phone, that was it. Now transmission today still ends there, but the wording until it's received by the user has a different meaning. So it was described as when it lands in the inbox. In the old way, in the web-based email services, where you had to previously basically download the email to actually be able to read it, that might have made sense still. But today, in the cloud, this transmission is much more fluid. So you have it in the cloud. It stays in the cloud when it's in your inbox as well. So you have a certain moment where it's not yet in your inbox. You get like a notice, you have an email, there is some spam filters and all of that. That's sort of in the cloud, sort of in the same cloud as when it's in your inbox. It's still in your cloud. But now with this change, suddenly we have a part covered by the ePrivacy regulation and part covered by GDPR. It's the same cloud. That sort of doesn't make much sense. Now, from the other side around, and this is sort of where we come to Article 11, what does that actually mean? So do I intercept or do I request an access to data? And that's sort of what's happening on the police force side of this. The Gmail case that was also decided by the European Court of Justice decided that this is not covered by the ePrivacy Directive or by the telecommunication rules that are still in existence will end to exist, being replaced by the electronic communication code, was not in there. So they fell outside of what the police could do in the interception discussion. So we have to look at what's actually happening on the police side and the law enforcement side, and how do they want to get access to this data, and what's happening there. So we also need to think about encryption in this context, and why we have Article 11 in this space. In agreement with Estelle, like looking at whether or not the national law should be covered by EU law or the European Court of Justice Fundamental Rights Charter, then we need to go back and say, well, if that is the case, what this ePrivacy regulation should have done is actually putting the safeguards right in there instead of leaving it to the national legislators alone. So in part, I think some part of the struggle with the ePrivacy regulation at the end of the day is that we were mixing up at least 4 very different topics. The one is data protection for telecommunication providers whose metadata is super sensitive. The confidentiality requirements that you should think of for any cloud provider that deals with communication. And then the law enforcement regulation, and that should have looked at the issues of encryption, data retention, and safeguards and limitations. You could actually separate out these three areas. There are some consumer protection issues in addition to that, and have deep and constructive conversations in trying to sort them out. And they will stay with us for quite a while because they are increasingly difficult. I mean, we all know the announcements of WhatsApp, and we also do know how law enforcement with increasing safety risks are increasingly asking for access to this data. But it's incredibly hard to make this, strive this balance. And so in order to have a really good societal solution in that space, it doesn't really help to punch this in a regulation in which we also talk about advertising rules, consumer protection rules, and other things. These things need to be separated out and really looked at in depth. And so again, I think in a way, leaving them all together was a lost opportunity to actually sort out some of the most fundamental societal question marks that we have in a digital world.
Thank you. We'll move to Joris van Hoboken, who's also been following this reform very closely and provided a lot of comments throughout the reform. Thank you.
Thank you, and thank you for having me here. There are quite some seats here in the front and also on that side of the room for people that are standing in the back. Please do feel free to move around and get yourself a comfortable seat. Just one issue in the interest of transparency. So in Brussels, I'm a professor of law. I'm appointed to the chair of Fundamental Rights in the Digital Transformation, which is supported by Microsoft. I'm an independent academic, but the money is coming from a company that has a strong interest in this space. I will also speak freely on these issues, as I like to do as an academic. ePrivacy is a wonderful file. I would if you're not already following this, I would totally recommend doing that. It's compared to a lot of other regulatory files, it's relatively easy to follow because it's not so big. And it's the text is not that long. But it's full of really, really complicated issues. Within those issues, within that issue space of ePrivacy, the intersection between consumer privacy and law enforcement has interested me always tremendously, and so that's what I will focus on. As a starting point, I think it's really good to acknowledge and to realize that something being called a privacy law doesn't mean it protects privacy very well. And this is, for ePrivacy, an important starting point. And one of the reasons for that is that in the telecommunication space, privacy protections have often been suboptimal. And one of the reasons for that comes from the law enforcement, national security interests that are implicated in this sector. And so, for instance, in the area because of the interest of the state to be able to wiretap communications, under, of course, legal procedures, and it's all rule of law, it's in the law when you're allowed to do that. But say, we want to be able to wiretap telecommunications when we have a valid legal order. This is part of telecommunications privacy regulation. So this is always, electronic communications privacy has always been limited by regulation, not necessarily only protected. So in ePrivacy, if you look at it at the European level, ePrivacy is a file that is about consumer privacy protections in the electronic communications sector. It's already been spoken about. And so the two main areas where you see the need for those protections is on the confidentiality of communications and on the communications metadata processing. Under what conditions can you process data about the communications? So, and then the rules, the ePrivacy rules, they're about harmonization. This is harmonization of the electronic communications services market. And so the ePrivacy rules were always part of the telecommunications package. No? So now what we have seen recently, if we start to move the ePrivacy a little bit out of the telecommunications package, and it's become more connected to the GDPR. It's become more a data-oriented set of rules. But in the end, the focus is on consumer business privacy issues, and which we know, of course, are really significant in the electronic communication space. There are a ton of issues that need to be dealt with. You know, like all sorts of issues around web tracking, all sorts of issues under what conditions can communication services do things with the content, with digital content processing, of course, communications content processing. There are a lot more opportunities to do things than there used to be in the traditional space. And metadata, of course, all sorts of interest to do things with metadata. So this is the area, this is what the European proposals are trying to achieve, regulate this consumer business relation on privacy aspects. But when you do that, it always, by definition, triggers government surveillance agendas. And this is not something new. No? So when the proposals came, you know, in 2015, 16, 17, start thinking like what we always know, this is going to happen. In the end, this debate, and maybe it will take some time, we have Article 11 with an exception, but over time it will become very clear that privacy proposals trigger these surveillance, these state surveillance agendas. Law enforcement on the one hand, but also national security. And of course, within national security, the communication space is one of the key focus areas, one of the key target areas for national security agencies to be to have an interest in having data from this space. It's the same like with the finance sector, of course, you know, and mobility. There's these key areas where national securities have a very, very strong interest and are very actively pursuing to maximize their interest to get data from this particular sector. So it's not only that ePrivacy has a relevant exception, Article 11, that says this whole set of rules is European level rules, harmonization of consumer privacy protections, and there are exceptions to that possible in the member states, in the law enforcement and national security area. No, it is also that there's an active interest in the way in which consumer privacy rules could limit or enhance the playing field for government law enforcement and national security agencies. You know, so it goes beyond just we need an exception. No, we have actually an active interest in how consumer privacy rules are shaping the playing field for state agencies that have surveillance needs. So for instance, and this goes a long way back, in around 2000, 2002, and that's the first debate that I tracked it. I wasn't there myself, but this is a time where there was a very active debate about this. The ePrivacy proposals, the directive ultimately adopted in 2002, which is still the key instrument that is in place now, amended in 2009. So this proposed consumer data privacy rules limiting collection and use of communications data. And so the idea was like telecommunications providers, they can only have the data for as long as they have a commercial need, and then they have to delete the data. So this was framed as data destruction. You know, this is going to destroy the data, and this triggered, you know, this law enforcement interest. This data should be there, you know, even though there's no commercial need. So this was at the time, later on, of course, for those who know the history, there were proposals for a data retention instrument in the third pillar. Then it became a directive that was finally annulled. And we know at the moment there is a very active pursuit still of data retention instruments at the national level, like was mentioned already by Estelle earlier. It does also work both ways. Companies sometimes also argue that they have to keep data of consumers and they will legitimize their commercial surveillance by pointing out that this data could be used for law enforcement purposes. And so there's, for instance, the example I can give is from Google at the time. In 2007, there was just a year after the adoption of the data retention directive saying, we have to keep all your search history because there's a data retention directive. You know, even though the data retention directive didn't really apply. You know, and at other times Eric Schmidt has said, you know, you do search, we need to keep this data on what people search for in case people do the wrong things, you know. So placing this commercial surveillance in a completely new light, you know, and also very clearly trying to, you know, mobilize maybe certain political forces, you know, within the state to, you know, help them to legitimize their own commercial surveillance. So these issues are not easy to separate, also politically speaking. So there are two key specific issues on the interface of ePrivacy and law enforcement at the moment. The one is the area is on data deletion, you know, like commercial deletion obligations versus data retention. And the other one is encryption. So, and the encryption is a little bit new, and this has to do for ePrivacy, and that has to do with the fact that the ePrivacy proposals have broadened the scope to so-called over-the-top services. So services like WhatsApp and Signal, they're now covered. And we know from just looking at the current market that there's a lot of these services that have end-to-end encryption implemented, which is really quite different from the situation that we have in the telecommunications sector, where we do not have end-to-end encryption practices, which actually not allowed because of the wiretap obligations. And this is quite relevant, of course, considering the popularity of what is there in the market. By broadening the scope of a set of rules, you know, that like for a sector that generally that hasn't had optimal privacy protections, it's quite risky for that broadening of scope. So it could be, you know, that this will ultimately also trigger some additional pushback. There's significant pushback already on this end-to-end encrypted communication services. But there's a second area, and Cornelia has already also mentioned that. This is because of the fact that closed channel social media, as I would call them, WhatsApp, have become very popular, have become maybe in many ways more popular than more semi-public social media. And this then concerns around content regulation, illegal content online, run into confidentiality requirements. So the debate that is now going on in the context of the Digital Services Act, you know, like what should be happening with illegal content online, you know, like a whole chunk of the dynamics, the social dynamics that's happening with content, social sharing of content, including illegal content, is happening on channels that do not have proper notice and action mechanisms that are actually within the ePrivacy space. So finally, on the data retention issue, I want to make a final remark, which data retention is uniquely interesting. I think it has the potential to, and it has already shown that it has that potential to trigger a European constitutional crisis. So what is the future for data retention? Just this month, as Estelle also mentioned, there were opinions on data retention. One big question is, will the member states finally give up? You know, like, so my prediction would be that the court is going to rule mostly in line with what the Advocate General also has said, like following the Taylor 2 judgment. But my intuition is also the member states will not give up. The member states, they are not happy with discriminate data retention. They want the full thing. Their vision for the future, for what their needs are, is data retention is a part of that. And I don't think there are also parts of government that are not happy to be restricted by a European court because they feel that they are working in an area that is not European competency, you know, and that's part, of course, of the litigation. And so there is a solution, I think. The solution is that the data retention laws, instead of putting obligations on private sector entities to keep the data, the national security agencies that want that data to be available set up specially organized repositories of data that are governed under national security law. You're outside of EU law if you do it like that. I just don't think politically our societies are going to buy this idea of setting up these type of repositories. It's going to be very clear that there's something very creepy and politically not good going on with our fundamental rights if we are living in a society where we have those kind of repositories that are set up for national security and counterterrorism purposes. So my intuition is that the member states will keep on pushing, and that could be, that can turn out to keep this file very interesting on the long run. Thank you.
Thank you. We will now hear from our last speaker before we move to the question. Sorry that you have to follow that last creepy note from Joris to have those repository created. Our last speaker is has been carrying this proposal from the European Commission for the past years, Peter Herbel. You will provide us with an overview of the ongoing reform, and since you also sit in the negotiation, maybe you can tell us a little bit more about a potential way forward. In particular, since, well, one state will be leaving us soon, and this state has voted against the privacy regulation, so maybe something will change. Thank you.
Okay, thanks, Estelle. Well, I inherited the file, so I haven't been there from the beginning, but I'm co-responsible for the inclusion of the OTTs in the definition. On the first topic, the state surveillance and the hidden agenda, which was the topic of the panel. From the Commission's point of view, yes, of course, I try to speak on my own, but I guess my statements will be still attributed to the Commission, but it's my own views. The Commission's view is, of course, that the protection is against state surveillance, but also against the private surveillance. And I think it was very well explained by Frederik why protection against private surveillance by the providers or by third parties, private third parties or state third parties, is very important, this horizontal effect, because it is essential for the trust of the users. And as he explained, the trust requires that there's absolute certainty that nothing happens to the communications. And as soon as there's some suspicion or some doubt, the distrust is gone. And we will have more and more data being transmitted, and so therefore for the in the data economy, I think it's essential that we have protection also against private surveillance. This has, by the way, been also emphasized by the President of the Commission. Even before she took office, she went to Berlin and gave the laudatio to the author of The Age of Surveillance Capitalism, Shoshana Zuboff. So I think it's one of her, or the Commission's key elements is this kind of human-centric approach and to protect the individuals against surveillance by states and by private companies. One comment maybe on Article 11. It has always been mentioned in the context of national data retention law, but it of course applies also to any union data retention law. If there's ever again a data retention directive or regulation, Article 11, the criteria of Article 11 of the ePrivacy regulation proposal, which is more or less like Article 15 of the current directive, will apply. And maybe one explanation or background, Joris mentioned the encryption issue and let's say the wishes of the law enforcement authorities to prevent that encryption. That is for the interception, so the kind of tapping during the communication, which is different from the data retention, of course, but it's one or other important state surveillance, but also state investigation measure. So, but Article 11 or 15 of the current directive applies to both data retention and interception. Then, regarding what happened in the Council regarding data retention, I think, of course, the Commission doesn't like the changes put forward by the Council, but I try to explain what the Council's background is. I think, and the Council is not a monolithic group in that sense. There are member states which want to strengthen the law enforcement powers, and there are others who want to defend or even strengthen the individual's rights. So it's not one position. There's a lot of debates going on. I think what the incentive of the Council was that is to have some clarification or some possibilities that data retention is possible. But I think the Council is also aware that they are bound by the jurisprudence and Tele2, and I think also the interpretations given by the two Advocate Generals today and last week. They both seem to derive the elements of Tele2 to a large extent from the Charter, and not only from the ePrivacy Directive. The ePrivacy Directive is a reference, of course, but many of the elements put forward in these judgments, or in this judgment and also in digital rights, is, in my view, derived from the Charter and is reflected and interpreted into the ePrivacy Directive. So much about this data retention, state surveillance issue. Maybe some words on the ePrivacy regulation, the way forward, and also why we need to have the regulation. I think the first element is that the current directive the implementation is inconsistent. We have relative big divergences between member states, and enforcement powers of the surveillance authorities or the competent authorities are really very divergent and also applied in a diverging way, so therefore a regulation is essential. Second, the ePrivacy Directive is outdated. In our view, and I come to that in a minute, what we need is to have a protection of the end users of all electronic communication services, and of all means of communications. And what we did in the code definition, which will apply to the ePrivacy regulation, and will apply, by the way, also to the ePrivacy Directive as from December this year, if there is no regulation enforced by then, is look at the consumer and look what means does he use, or he or she use for communication purposes. That led us to include certain communication services like Gmail, WhatsApp, Hotmail, or Outlook, and so on. To some extent, so this level playing field, level consumer protection is addressed by the code, but it's also regarding the permitted processing or the grounds for processing. So what can a communication service provider do with metadata or even content data? I think there the directive is also outdated. I think there is consensus, also the Parliament, for instance, agrees that communications data may be used or processed by providers for the purpose of securing their networks and services against malware and viruses. Also, what the provider can do with the user's consent, I think, is also very limited in the directive. So I think there should also be more possibilities. Then, of course, there are divergences. The Council has added quite a lot of grounds for processing, whereas the Parliament has, of course, a more restrictive view. But I think that can be solved in trilogues, and I'm sure that will be solved there. But most importantly, and that's my third point, why we need the ePrivacy regulation is the protection of confidentiality becomes more and more important. And I think that has been illustrated again by Frederik's presentation. You all remember the recent incidents with data leaks, with some WhatsApp incidents, which will be, of course, covered in the future. And I think that's important for the user trust. And I think for those who have doubts whether the ePrivacy regulation should come, I think the directive will not go away for the reasons we had heard tonight, that because it is necessary for the protection of the confidentiality. But if somebody is not happy with the current text, both in the Parliament or in the Council, they should work with the legislators to work on that. But ePrivacy directive will not disappear, and I think the best way to address the issues is the regulation. On the way forward, briefly, so there was, I think, some confusions as to whether what the Commission would do. I think an answer has been given today quite clearly by the Croatian State Secretary in the Parliament. The Croatian Presidency will come up with a new text in February. Of course, the Commission works with the Presidency, with the other member states, also with the Parliament, and so we will hope to bring that to a good end. I have just maybe two comments on what Cornelia said. I think the inclusion of the OTTs is not an issue of market regulation. I think it applies mainly to the consumer protection, the end user protection, and I think then there's not a big difference between a consumer and a data subject under the GDPR. I think that is what is the main reason for the inclusion. The OTT services will not be market regulated as having a dominant position and therefore having to give access and so on. I think that is maybe one of the collateral aspects in the future, but the purpose was clearly from the perspective of the end user to protect them. And then maybe I misunderstood it, but the fact that law enforcement authorities may request now in the future data retention or interception from WhatsApp, Gmail, and so on, I think that is not an argument to not include them into the protection, because, okay, then I misunderstood, because I think that law enforcement authorities or member states had already included sometimes the OTT service in the data retention or lawful interception obligation, so that is not an argument to exclude them from the protection. And then the argument that there are many issues in the addressed in the regulation, that was also the case in the directive, of course, and maybe it could have been better some years ago to split them. But I think now this looks to me rather like a kind of creating additional delay, and I'm not sure that is something what we need now.
Interesting. So just on the consumer part, it's really interesting because some of these rules apply now, and so it's not that they were unregulated. The general consumer protection rules actually apply to these services, and you can make a comparison between the general consumer protection rules that applied versus those that were specific to the telecom regulators. The reasons for these special telecom consumer protection laws were one that you have really only one provider and you can't switch. So there were a lot of issues, and you can basically, I was at one event where we had the Belgium telecom regulator giving a presentation on the complaints of consumers in the context of telecom, the traditional telecom services. And I sort of personally could totally subscribe to some of those. They related to like unclear bills, and there were all these issues that actually don't really occur in OTT services. Most of them on top are free of charge, and we can talk about what free means, which is yet another debate. But the specific rules are in parts meaningless in the context of these services. So we were also falling into a funny level playing field discussion, which was clearly a level playing field argument is always a non-market strategy by one sector. So the area of the protection, the additional protection, I think can be debated. That by covering or by bringing them into that regulatory regime versus the general consumer protection rules is non-existent.
We have about 15 minutes for discussion, but if I may actually come back to your point, because I'm not sure I fully understand it. So you are arguing that so-called OTTs should probably not be in the scope of ePrivacy because you're already protecting them, so you don't need to have additional protection?
No, this relates, so this little debate here, but didn't relate to the ePrivacy regulation, but to the Electronic Communication Code.
Okay.
So ahead of the ePrivacy regulation, there was a 3-year discussion, and we had the opportunity to discuss this a couple of times, whether or not OTTs actually fall in scope. In fact, this is a debate that already started with the last telecom reform where the Commission was trying to expand by changing the definition, the OTTs into scope, which led to this Gmail court case, for example, which led to the Skype court case. And it's a really interesting, goes into a very different direction, a really interesting comparison between the Skype European Court of Justice decision and the Gmail European Court of Justice decision. Gmail was not considered an electronic communication service under the current framework, which will be changed, but Skype out, not Skype, Skype out was because Skype out has the ability to connect to the telecom network through numbers, and we do this through a telecommunication provider, a traditional telecommunication provider, whom we have contractual relations, and by extension the court said, well, because of that, this is actually an electronic communication service. So Skype out was already ruled that it already falls under the telecommunication framework that is in existence today. But this is one of these aspects which I made the point that it is really, these are really technically difficult distinctions that we didn't have the time to actually dive in because there was such a mix of issues and different lobby agendas that didn't allow for that discussion to actually happen. And on the encryption, really, I mean, who knows the answer to how to deal with this issue? And instead of having this in a lobby fight, I think it would be worthwhile to give this to some experts that don't come with one solution, as the Commission did, but rather to have options out there that then are clear to society. You can't have just one option and then fighting over it for 3 years. I think that's our societal freedom is worth more than that.
Right. I mean, obviously the lobbying fight, which I'm just allowing myself to respond because it's civil society and company who've been a lot on this discussion, but we would have liked also to have other discussion for the last 3 years other than on child exploitation and on data retention in the context of ePrivacy and discuss what constitutes a communication and what does it mean when I'm a user. If I send a message over WhatsApp or a text message, is my confidentiality protected or not, and to which point indeed. Which hopefully with more clarity on the court rulings on some of those issues, it will come and try to redefine what ePrivacy really is about. I want to make sure I turn to all of you for any question you want to ask any of us, any comments you would like to make. I've seen a lot of people in the room who's been also very active on these files for the past 3 to 4 years or more even. So please feel free to come in, or if you have anything to add. Right. Yes, there is a suggestion to take question as a group and then we come back. There is, and we know, a reception coming out after that, so question will lead you to the reception. Then. Great.
No, then I'll make a remark myself again. So all this delay has an interesting effect because now all member states have national laws, telecom laws, that are in many member states. The current ePrivacy rules are from a directive, so are in national telecom laws. So for instance, and the current ePrivacy directive only applies to publicly available electronic communication services, basically the telecom companies. So if you have some, my parents still use it, the email that they get with their internet access provider. That internet access provider has to comply with confidentiality of communications because of the current ePrivacy directive. Gmail is outside the scope of the current ePrivacy rules. Skype to Skype calls are outside the current ePrivacy rules. But now, so that means that if Skype wants to train their, hypothetically, if Skype wants to train their on-the-fly translation AI, then they will, Skype has to comply with the GDPR, so we'll start looking consent, perhaps contractual necessity, perhaps legitimate interest, so they can look at different legal bases in the GDPR. Under the ePrivacy Directive, it is only consent. So it makes life of the Gmails and the Skypes in this world easier. Now, the electronic communication code makes the definition of publicly available blah, blah, blah much broader. 31 of December, the current ePrivacy rules that each of the 27, by then, member states have suddenly a much broader scope. We'll have to see that how that plays out, but I wonder whether each Silicon Valley lobbyist saw this side effect coming of slowing down the ePrivacy regulation, because yeah, all the Gmails in this world suddenly have to comply with the very strict communications confidentiality rules that were written for basically cell phone companies and access providers. Interesting times. I have my popcorn ready.
I think we're between the audience and drinks, I have the feeling. But I do have a question. I'm going to ask a question to my neighbor. This is a question I've had for a while. It has to do with the extension to OTTs and the intersection of consumer privacy and the law enforcement issue, the Article 11. So there's a difference between OTTs and more classic telecommunications in terms to the territoriality of service provision. So for telecommunications companies, typically they're connected to the territory. These are companies that are based in, in the country. They have to operate in many ways. Of course, there are ways in which there can be wholesale and there are services. There's some flexibility there also because of the liberalization of the telecommunications market, but there is a different territoriality connection between telecommunications providers and OTTs, which can offer their service from Brazil or Japan or Russia or the United States. And what is very interesting about Article 11, so the ePrivacy rules have in particular restrictions on what electronic communications providers can do with the content and with the metadata. And they set restrictions, and then they give some exceptions. So then Article 11 gives the member states and union law, these two things, the possibility to break that a bit and to broaden what can be done with the data. And by extending this to OTTs, like this very interesting thing is happening that Article 11 only gives union law and member state law the possibility to provide for these exceptions. So let's say WhatsApp data retention for law enforcement purposes. Discriminate data retention in line with the charter. Let's be in line with the charter. But let's say, well, WhatsApp, of course, a company operating out of the United States. What if Californian law or US law says, you are operating this type of company, we have seen you do this work now long enough in ways that don't fulfill our law enforcement needs, we're gonna put you under a data retention obligation. That would break potentially, like ePrivacy rules, but it would be a complication. Has the Commission thought about this complication about Article 11 and extension to the OTTs? I hope that my question is clear. It's a little bit technical.
It is. Well, I think the traditional telecoms are also not purely limited to one territory. They have cross-border activities, they have international calls, they have data traffic and so on. But related to your specific issue on the state intervention by a third country, yes, you're right, Article 11, and I think as Article 15 of the directive refers only to union or member state law, which means it's not a third party's law. So let's say a US obligation to retain data, to give access to law enforcement authorities is not covered by Article 11 or 15 of the directive. And then we come to a situation where we have possibly contradictory obligations on providers. But that is not only under European communications or ePrivacy law. That exists in many areas, and we have to solve these issues. And we have other jurisdictions which have a kind of even more extraterritorial effect and more, let's say, imposing their law on companies outside their territory. So I think that is nothing new, and we have to solve that. We have this issue, I guess, also under GDPR. We have that in competition law. We have that.
But let's say, like you have WeChat. I don't know exactly under what obligations WeChat is in China, also extraterritorially. But I imagine it could be not in line with the ePrivacy rules. Would, I think it's Tencent, would they have to offer a European version of WeChat that complies with? Would that be the idea of the Commission, that then you would have this OTT versions for the European market?
Again, this is not an ePrivacy specific issue. This is in GDPR also applies. A company which wants to provide services in Europe has to comply with the union law. We have that competition law as well. If you want to sell products or services in the union, in the common market, I think you have to abide to the European rules. I think that is obvious, and that has been backed by jurisprudence, as long as it's not somehow arbitrary and so on. And regarding other services and GDPR related, well, GDPR ePrivacy related, I think the Washington Post has an EU offer where you have a paywall and you pay a bit more even so that you don't get cookies. So you have a US pay offer where you pay whatever, $5 and you get still cookies, and a European offer which offers you you have to pay, but you don't get cookies. I think companies abide to these rules. It's not an ePrivacy specific issue.
So let me, if I may, just it's sort of like a combination of your question. Yes, we are aware, and the more interesting point here is actually because is the fact that telecommunication rules. The enforcement authorities are national in telecommunication, and in the electronic communication code, there is the possibility in an annex for member states to demand intercept capabilities. It's not the request, but it's the capability to actually intercept, which means for providers to actually, in that country, in order not to be infringing in another country, to have that capability in town. And this is sort of the crux of this whole Article 11. There are so many angles to it. So by expanding the scope, this capability. That is sort of a hidden side effect that before a company that does, for example, end-to-end encryption, or is just not simply in that country with any equipment, can always say, well, we can't actually do that. And there is interesting dimensions to that. Microsoft had lost a case in Belgium, the Mechelen case in this context. But again, one other angle that needs to be looked at in the broader picture of what does a civil society actually want from the ePrivacy Directive. We want to go back to the point that Joris made, is this actually protecting, or is it a big loophole in the protection of rights? And I'm making this, there's too many, I see there's too many people that tweet, so I will not make that statement, but I will do a statement at the coffee bar later on on precisely that.
If I may answer that and then just conclude so we can move on to the reception, because you addressed directly to NGOs on what we want from the ePrivacy. I think it would be a misconception to think that member states are only using ePrivacy as a way to expand their surveillance apparatus. The fact that they would want to get the same access that they get through telecom operators through OTT is happening. They want it through ePrivacy, that is true, but ePrivacy is here to set safeguards, it's not a surveillance tool again. And of course, we're aware of risk. This is why civil society is the one actually sending the data retention directive and all of the data retention law in front of the CJU. It was brought by Digital Rights Ireland, Privacy International, La Quadrature du Net, and all of our partners. So we know that very well, but that doesn't make the necessity for ePrivacy and for confidentiality of communication that it's supposed to be protected less relevant, which I know it's not what you're saying, but we are aware of the risk, but we're also aware of the jurisprudence that has been built to try to prevent that from happening. It just seems that the debate can be going on and over, so I will just stop here and we can continue over drinks. As you can see, obviously the whole question of surveillance state, ePrivacy, and many other questions came up of privacy versus paid access, encryption. Many other issues came up in this debate and can be also expanded much further. So maybe if I can leave you with just a wish, is that by CPDP next year we discussed finally adopted privacy regulation that would be protecting privacy and confidentiality of communication, but we shall see. Thank you very much. Have a good evening and a good CPDP. And thanks to all panelists also.